이번 순서는 기조연설입니다. 기조연설은 일본 지적재산고등재판소의 시타라 류이치 소장님께서 해주시겠습니다. 시타라 류이치 소장님을 박수로 모시겠습니다.
Good morning. Thank you for inviting us to this international conference. I'm a Chief Judge of IP High Court in Japan. It's my great honor to speak in front of prominent judges and professors and practitioners. I hope this conference will deepen our mutual understanding of the patent litigation system of each country. Today I would like to explain several characteristics of patent litigations in Japan and its future development. According to the amendment of the Civil Procedure Code in 2004, we have an exclusive jurisdiction system in the technological IP cases. The Tokyo District Court had the exclusive jurisdiction over the technological cases in the eastern region of Japan. And the Osaka District Court has the exclusive jurisdiction over the technological cases in the western region of Japan. So each of the Tokyo and Osaka District Court has the overlapping jurisdiction with the other district court over the types of IP cases, such as trademark, copyright, or unfair competition prevention law cases. There are four divisions, and there are four intellectual property divisions in the Tokyo District Court and two IP divisions in Osaka District Court. And this means these 6 IP divisions of the Tokyo and Osaka District Court decide all the patent infringement cases in Japan as a first instance court. Approximately 16 judges and 7 judicial officials are serving at the IP divisions of the Tokyo District Court, and 5 judges and 3 judicial research officers are serving at the Osaka District Court. Types of IP litigation in the first instance court is shown in this chart. Patent infringement cases are the most important IP cases in Japan, and trademark and copyright and unfair competition prevention act cases are the next important IP cases in Japan. As you may see from this chart and the numbers of judges, the number of IP cases handled by the Tokyo District Court IP divisions is more than 3 times of those handled by the Osaka District Court IP divisions. The average period from filing an action to a delivery of a judgment or a judicial settlement by courts for first instance court is around 15 months. As it is shown in this chart, the average period for a first instance court was 31 months in 1993. At that time, our industry criticized the court that it was too late to get an injunction order in 3 years after filing an action. So we speeded up the procedures of patent litigations. With the cooperation of attorneys and IP divisions of a private company, and we also increased the number of judges in IP divisions of the court, and now it will take just 15 months. And as to the appeals of the patent infringement cases, the Intellectual Property High Court, which was established in 2005, has an exclusive jurisdiction. IP High Court also exclusively decides the appeal cases against decisions made by Board of Japan Patent Office. And there are 4 IP divisions and almost 17 judges and 11 judicial research officers are serving at IP High Court. Consequently, IP High Court decides every patent infringement appeal cases and every appeal cases against patent invalidation decisions or rejection of patent applications by JPO board. The average period from filing an appeal to a delivery of a judgment or settlement by IP High Court in IP infringement appeal cases is around 7 months. And the number of IP appeal cases per year is roughly 110 or 130. And the average period from filing an appeal to a delivery of a judgment by IP High Court in appeal cases against JPO board decisions is about 8 months. The number of such appeal cases per year is declining from 600 to 300 in these 10 years. Besides the judicial research officers, we have an expert advisors system. Expert advisors are the university professors or researchers, and they are part-time court members. They know the technology, but they are not familiar with the Patent Act. After filing an action, periodical oral hearings or preparatory proceedings will be held for several times until necessary arguments and evidences are submitted by both parties. When I served as a presiding judge at the IP division of the Tokyo District Court, on the first oral hearing date, I asked the parties what are the main issues of this case, and after that, I decided the schedule for submitting the briefs and evidences after, evidences. Generally speaking, the main issues of patent litigation are interpretation of the claim and invalidity defense. The attorneys of both parties, plaintiffs and defendants, usually submit all the necessary briefs and evidences within 8 or 10 months in an ordinary patent infringement cases. After the parties submit all the necessary briefs and evidences, the court may have the explanatory sessions. In this session, for both parties using PowerPoint slides and clearly explain the technology of the patent and present their assertion and evidences and clarify the issues of the cases. The main duty of judicial research officers is to explain technologies to judges, to let the judges understand technologies in each patent litigations. It is not necessary for Japanese IP judges to have technological backgrounds, so it is not easy for a judge to understand the technology written in patent specifications if it is a technology in semiconductors or electronic communication devices or biotechnologies or other advanced technologies. However, after we heard the explanation by judicial research officers and after we asked many questions about the technologies, judges can understand the patent specification or other technical documents and briefs, which is necessary to decide the case. According to my experience, it is not necessary for a judge to have a wide range of technical knowledge, but it is necessary for a judge to understand the technology accurately and efficiently. Now I have to explain who the judicial research officers are. They are consisted of experienced patent examiners and patent trial examiners and patent attorneys. Before becoming judicial officers, they have to quit the JPO or a law firm and become an officers of the court. Most of them generally serve as judicial research officers for 3 years and return to JPO or a law firm after 3 years. Then you might have a question whether they are neutral in litigations, rescinding and trial decisions by JPO. According to my long-term experience, judicial research officers, they traditionally show very strict opinion against mistakes in the decisions made by the trial examiners by JPO. So you don't have to worry about their neutrality. Our Supreme Court decided in Kirby case in 2000 that if the patent is apparently invalid, such a patent holder may not exercise patent right in a patent infringement litigation, since it constitutes an abuse of right. Before this judgment, invalidity of a patent could only be decided in the invalidation trial by JPO. After this Supreme Court judgment, Patent Act was reformed to introduce invalidity defense. Not only the claim interpretation, but also the invalidity defense are the most important issue in patent litigations of Japan. The judgment which permits the invalidity defense does not have an effect to publicly invalidate the patent. So invalidity procedure in JPO trial still remains. This is called double track system. But this is different from bifurcation system in Germany. This invalidity defense is very important defense for an accused infringer when the main reason for him to fight with the patentee is that the patent has a reason to be invalidated. It is practically important for the parties that the infringement and validity of patents shall be simultaneously decided by the court. Now the court can decide the infringement and now the court can decide the injunction and damages with full confidence after courts considered not only the infringement but also the invalidity of the patent. Settlement, judicial settlement is an important practice in Japan, so I'll explain this practice very briefly. When courts find infringement in patent litigations, panel of judges generally proceed to judicial settlement procedure. In the settlement procedure, a judge in charge of a case will disclose a panel's opinion, particularly to the losing party. After hearing plans for a settlement from both parties, a judge will propose an appropriate settlement plan to both parties. In the settlement procedure, both parties will try to find an appropriate and flexible solution to end the conflict. In this judicial settlement, a license agreement would be made or settlement money would be agreed, and other necessary things will be discussed and agreed. In Japan, judicial settlement controlled by a judge at the final stage of the patent litigations are one of the useful tools to end the conflicts in an appropriate way. On the contrary, when courts find no infringement in patent litigations or courts find invalidity of patents, it is very difficult to settle the case, and courts will generally proceed to a delivery of judgment. This is why the winning rate of a patentee in judgments regarding the patent litigations in Japan is low. It's just 15%. When we try to find the substantial winning rate of patentees in patent litigations, we have to include the numbers of these settlement cases in which patentee won. This chart is based on the recent research regarding the settlement cases in the Tokyo and Osaka district courts in 2011 and 2013. When we look at the outcome of cases ended by judgments, it's just only 50%. But according to this recent research, the total number of cases in which patentee won is approximately 45%. So this shows a substantial winning rate of the patentee in the patent litigation in Japan. Finally, I have to add, that the settlement procedure lacks transparency, and it would not be good if judges misuse their power to settle the case. But this practice continued for a long time in Japan. I hope this judicial settlement practice will continue as a successful practice in the future. I would like to mention to the recent tendency in the patent litigations by explaining Apple versus Samsung case. This was a symbolic legal conflict between the two giant companies in the world, which shows the international forum shopping. 7 patent litigations and 10 preliminary injunction motions were filed to the Tokyo District Court by these two companies. And 4 judgments and 8 decisions were delivered and appealed to the IP High Court. IP High Court delivered 3 judgments and 5 decisions. The last one was a Grand Panel judgment and decision delivered on May 16, 2014. Before establishing the IP High Court, there were already 4 IP divisions in the Tokyo High Court. And for the actual effect of the establishment of IP High Court is shown in the international exchange. These are the recent international symposiums and events. From the year of 2014, the number of visitors to IP High Court is rapidly increasing. Many of them are coming from Asian countries, in which the number of IP conflicts are increasing, and the speedy and appropriate legal solution of the speedy solution are demanded by the industry. The final issues is what's the new plan in 2016 of the intellectual property strategy headquarters of Japan is. One of its important new plans in 2016 is to establish a new evidence collection system in patent litigations. The new system will be an inspection system which is similar to but partly different from the inspection system already adopted in German patent litigations. Germany has already adopted this system more than 10 years ago. This new inspection system will be a new issue to be discussed in the patent committee of the MIT's MIT's Industrial Structure Council in 2016. The Patent Committee will discuss and try to find out the new inspection system which will fit to the Japanese societies and companies and will conform to the patent litigations in Japan. Thank you for listening.
합뼈 아리가또 고자이마시타. 좋은 말씀 전해주신 시타라 류이치 소장님께 여러분 다시 한번 뜨거운 박수 부탁드립니다. 오늘 개회식에서 좋은 말씀해주신 연사분들께 감사드리며 이상으로 오전 행사 모두 마치도록 하겠습니다. 곧이어 기념 촬영이 있을 예정이오니 연사 및 귀빈 여러분께서는 단상 위로 자리해 주시기 바랍니다. For photo session, all the speakers, please come up to the stage. 촬영이 진행되는 동안 공지사항 전달해 드리겠습니다. 점심 식사는 별도로 제공되지 않으며 11시 30분부터 행사장 로비에서 전시물을 관람하시면서 핑거푸드를 즐기실 수 있는 콘텐츠 카페가 오픈될 예정입니다. 자료 또한 무료로 배포될 예정이니까요. 많은 이용 부탁드립니다. 또한 점심시간 이동하실 때 통역 수신기는 자리에 두고 가주시길 부탁드립니다. 오후 세션은 1시부터 시작될 예정입니다. 오후 세션에도 많은 참석 부탁드립니다. 즐거운 점심시간 되시길 바랍니다.